Welcome to the online discussion on Indian Penal Code. So far, we have covered the sections up to 24. Now let us discuss the provisions of section 25. What it provides? Fraudulently. Fraudulently, how it has been defined? A person is said to do a thing fraudulently if he does that thing with intent to defraud but not otherwise. What do we mean by defraud? Defraud has not been defined. So defraud is to be understood as defined in the dictionary meaning. Defraud comes when there is a deception and thereby somebody gets some monetary gain or somebody gains. So unless there is a deception and second there is a gain, there cannot be defraud. So what it says? A person is said to do a thing fraudulently if he does that thing with intent to defraud. If doing of a particular act is there with intention, that there will be a deception and thereby somebody will get some financial gain, something on defrauded. So here, then that will be treated as fraudulently, but not otherwise. Again, again it has been excluded other things. So a person is said to do a thing fraudulently if he does that thing. There must be an intention to defraud, but not otherwise. Defraud is not defined. Then why defraud? What is defraud? Defraud. So here defraud, there must be a deception. What is deception? By concealing something, there is a creating belief. By concealing, deception is practiced. Deception can be practiced, may be practiced in any way. There may be deception. In personating somebody, there may be deception. Or deception, conceal of certain facts. By concealing certain facts, concealing of something, thereby some advantages, but that is fraudulently. Now section 26, reason to believe. Reason to believe, you see, why reason to believe? It is everybody knows what is reason to, but it has been defined in otherwise. How? A person is sure to have reason to believe a thing if he has sufficient cause to believe that thing, but not otherwise. What is sufficient cause must be there. Simply must not be some that because somebody believes without any cause. That will not be a reason to believe. Reason to believe he has reason to believe that he is doing it good faith or for certain purpose. That is reason. Sufficient cause must be there. A person is said to have reason to believe a thing. A person is said to have reason to believe a thing if he has sufficient cause. There must be sufficient cause to believe that thing, but not otherwise. These two things, 25, but not otherwise. Here it has been otherwise it will not be treated as a reason to believe. Similarly, fraudulently, a person is said to do a thing fraudulently if he does that thing with intention to defraud, but not otherwise. Similarly, here reason to believe, a person is said to have reason to believe if he has sufficient cause to believe, but not otherwise. Then, 27, property in possession of wife, clerk, or servant. Sometimes when property is in possession of somebody's clerk, somebody's servant, somebody's wife, but temporarily period, then that will be treated as that property will be treated as if that property is in the possession of that property, of that person. What it says, when property is in the possession of a person's wife, clerk or servant, how? On account of that person's, on behalf of that person. When some property is in possession of somebody's clerk, wife, or servant. Three things: clerk, wife, or servant. On account of that person's, it is in that person's possession within the meaning of this code. So possession, theft, property Whenever a property is taken, somebody is from out of possession of another. Possession of another means when a property is in the possession of somebody's wife or somebody's clerk or somebody's servant, then in such case, on behalf of that person, on account of that person, then that will be treated as if that property is in possession of that person. Explanation further provides, then who will be a clerk? A person employed temporarily or on a particular occasion or for a particular occasion, for a particular purpose, in the capacity of a clerk or servant, temporarily or on a particular occasion, in the capacity of a clerk or servant, is a clerk or servant within the meaning of this structure. So now, it must not be a permanent employment, then temporarily, or on a particular occasion, or for a particular purpose, or particular occasion, for some certain short period also, if a person is also employed as a clerk or as a servant, even a private servant, private capacity, a person is appointed as a clerk, clerical, that is clerk. So he will be treated as a clerk within the meaning of this section. So section 27, what it says, property, when that property is in possession of somebody's clerk, somebody's servant, somebody's wife, on account of that person, then that will be treated as if that the property is in possession of that person. Then for appointment, no necessity, even on a particular occasion, for a particular purpose, somebody is appointed as a servant, that is, or a clerk, to do for a particular occasion. Occasion means, suppose, for a particular thing, one or two, for 2 days also, on one occasion, any one occasion, if a person is appointed, that will be treated as servant. So now, section 28, that is counterfeit. Counterfeit means, counterfeit has been defined here. Everybody know, when a person, what is? A person is said to counterfeit. A person is said to counterfeit. You should understand the definition of counterfeit, because counterfeiting coin, counterfeiting government stamp, counterfeiting notes, those are offenses. So unless you know the definition of counterfeit, what is counterfeit? Preparing something to resemble another thing. Resembling another thing. Somebody prepares a thing, makes a thing which resembles another thing. What is that? Because merely preparing or making a thing resembling another thing, that will not be treated as counterfeit. But with an intention that there may be deception. By making such thing, somebody will deceive somebody. Then that will be treated as counterfeit. What it provides? A person is said to counterfeit who causes one thing to resemble another thing, intending by means of that resemblance to practice deception. A person is said to counterfeit a thing who causes one thing to resemble another thing. A person is said to counterfeit a person is said to counterfeit a thing who causes one thing to resemble another thing. Who causes one thing to resemble another thing, but intending by means of that resemblance. Intention is that by means of that resemblance to practice deception. So that will be treated as counterfeit. A person is said to a person is said to counterfeit. Not now said to counterfeit when he causes who causes one thing to resemble another thing. Who causes one thing to resemble another thing. Suppose a 500 rupee note is there. A person causes one thing, another thing, prepare a similar thing to resemble that 500 thing. Suppose any stamp that is coin. So here, a person is said to counterfeit who causes one thing to resemble another thing, intending by means of that resemblance. Intention must be there by means of that resemblance to practice deception, or knowing it to be likely that deception will thereby be practiced. Intention is there, intending to practice deception, or knowing that it to be likely, deception will thereby be practiced. Likely possibility of practicing of deception. A person is said to counterfeit who causes one thing to resemble another thing, intending to practice deception, intending to practice deception, or knowing it to be likely that deception will be caused. So it is not required that the deception that is making up the resemblance must be exact. Resemblance must be exact. There must be what it says. It is expansion one says. It is not essential to counterfeiting that the imitation should be exact. That means it is not necessary that imitation must be exact imitation. So here just one thing to resemblance. It is not necessary that imitation, that must be imitation, resembling. So it is not necessary that imitation must be exact. Then expansion 2 says, when a person causes one thing to resemble another thing, and the resemblance is such, one person causes one thing to resemble another thing, and the resemblance is such that a person might be deceived thereby. The resemblance in such a manner, resemblance has been made in such a manner that a person might be deceived thereby. It shall be presumed until the contrary is proved. It shall be presumed. The court shall regard it exists. It shall be presumed until contrary is proved that the person so causing the one thing to resemble the other thing intended by means of that resemblance to practice deception, or knew it to be likely that deception would thereby be practiced. So, if the resemblance is such a nature that a person might be deceived thereby, if the resemblance is such that thereby a person, by seeing that resemblant thing, a person can be deceived thereby, then we shall presume that contrary is true, that person so caused the one thing to resemble. The court shall presume that the person has caused that thing to resemble another thing with intent to deception, with intent to deceive another, or with the knowledge, or he knew that it is likely to be deception would thereby be practiced. So, counterfeit in section 20 cannot an exact reproduction. Exact reproduction may not be there of the original counterfeited. The expansion to provides what is of great significance. It lays down that a rebuttable presumption where resemblance is such that a person might be deceived. When the resemblance is such a nature that one can be deceived, easily deceived, or that is made deception or knew it to, so there will be a presumption that he had intended to prepare that resemblance thing, imitation, with the intention to deceive somebody, or knew that by such deception, that deception would be, by such resemblance, deception would be practiced. So here, this is section, what is counterfeit? You should understand what is counterfeit. Counterfeit means making one thing to resemble another thing, or causing one thing to resemble another thing, and that was it. Mere resemblance is not, if that is intention to deceive somebody, or person knew that thereby deception may be practiced. So in such case, that will be counterfeit. So counterfeit doesn't mean that the imitation must be exact, but when so imitation is of such a nature that one can be deceived, that such a person might be deceived, there is possibility of deception. So in such case, it shall be presumed, court shall presume that such thing has been resembled with intention to deceive, or that the person knew it to be likely to be used for practicing deception. So now, section 29. What says document? You are aware there is a definition of document in the Evidence Act, but here in section 29 there is another similar definition is there. Only the difference is that in this Evidence Act intended to, which may be used to record it for the purpose of recording, but here only that intended that may be used in evidence. What document says? Your document denotes any matter expressed or described by upon any substance. Any matter expressed or described only on any substance. By what? By means of letter, figure, mark, or by more than one of those means. Either letter, figure, mark, or by more than one of those means. What? Intended to be used or which may be used as evidence of that matter. Here it has been intended to be used or which may be used as evidence of that matter. Similar definition there in the Indian Evidence Act. Any matter expressed on any substance by means of letter, figure, mark, or by more than one of those means, intended to record it. But here, intended to be used or which may be used as evidence of that matter. That is the document. So evidence doesn't mean only the person has made the intention that it will be only used in court of law. No. What said? Expansion says it is immaterial what means or upon what substance the letters, figures, or marks are formed, or whether the evidence is intended for or may be used in a court of justice or not. Explanation clarifies it is immaterial on what substance, on what it is immaterial by what means or upon what substance. What means what? Whether by means of a pencil or by means of a letter, or that means a ink pen or by means a dot pen, or any by what means, or on what substance. What substance means? It may be paper, it may be copper plate, it may be stone, it may be, or any, on what substance, by what means and on what substance. It is immaterial. The letter, figure, or marks are formed. The letter, figure, or marks are formed. Or whether means, or whether the evidence is intended for or may be used in a court of justice or not. Whether at the time of preparing or recording such things, that is expressing such thing, it has been intended only to be used in court of justice or not. So illustration will make you clear what it says. A writing expressing the terms of a contract, which may be used as evidence of the contract, is a document. Because writing, that letter, figure, mark. Writing is there, that reducing the terms of the contract with an intention that it will be used in evidence, that is a document. A check upon a banker is a document. What is check? Check is an unconditional order. A bill of exchange. Check is a bill of exchange drawn on a banker. That is check. What is bill of exchange? Bill of exchange has been defined in the negotiable instrument. Bill of exchange is an unconditional order in writing, directing a person to pay certain money on that person's behalf to another. So that is bill of exchange. When bill of exchange is done on a bank, that is called check. So here, a check upon a banker is a document because it may be used as evidence. A power of attorney is a document. Power of attorney means? Power of attorney means contract of agency. Somebody is given power to do something on behalf of some person. A map or plan which is intended to be used or which may be used as evidence is a document. Map, plan, map settlement, maps, these plans that may be used as evidence, that is a document. A writing containing directions or instruction is a document which may be used as evidence. Now explanation 2. Whatever is expressed by means of letter, figure, or marks, as explained by mercantile or other uses. Suppose as per mercantile or other uses, whatever is expressed by means of letter, figure, mark, shall be deemed to be expressed by such letters. Suppose in mercantile mark is there, mercantile this usage is figure or marks within the meaning of this section, although this same may not be actually expressed. Actually, suppose for an illustration, this illustration will make you clear how this mercantile or other usages, if something is expressed, that will also be treated as document. How? A writes his name on the back of a bill of exchange payable to his order. Simply writes his name. The name of the bank, he writes his name. The meaning of the endorsement, as explained by mercantile usage, somebody signed, suppose on the back of the bill of exchange check, somebody signs. So is that the bill to be paid to the holder? Once, because mercantile usage is that who, if a person signs on the writes his name on the back of a bill of exchange, that is the check on a bank, and simply handed over to another person. So it will be treated as a document. What is that? That it shall be treated, it shall be construed, as though nothing has been mentioned that evidence is there, it will be paid to some person, but it shall be construed that it is to be paid to the person who is the holder. The endorsement is a document. So simply writing somebody's name, how that becomes a document as per this provision. What is that? Which may be used as evidence. What type of evidence? That somebody signs, writes his name on the back of the bill of exchange or a check. Thereby, the writing becomes a document. What type of document? That evidencing that it was transferred to the person who holds the check. So here, the endorsement is a document and must be construed in the same manner as if the words paid to the holder. Though paid to the holder has not been mentioned there, because as per the mercantile usage or mercantile rule, that is practice, when somebody writes on the back side of the bill of exchange or a check, then that will be presumed, that will be construed that it is to be payable to the holder. Though payable to the holder has not been mentioned, that is to be construed. The words to that effect had been written over the signature. No, or words to that effect had been written over the signature. Section 29A, electronic records. Electronic records has been defined as per the Information and Technology Act. But it provides the word electronic record, some of the meaning assigned to them in clause T of section, clause F of section 1 of section 2 of the Information, and clause T of section 1 of subsection 2 of the Information Technology and valuable security. Sometimes it creates a confusion. When you say valuable security, somebody puts a question, what is valuable security? Unless you understand the definition or you remember the definition, sometimes you will be in confusion. Valuable security, valuable things. No, you must not confuse yourself. What is valuable security? Or a things given as security, or a valuable things given on security. That is not the definition. So always valuable security is a document. Valuable security is a document or purport to a document, or either document or which appear to be or said to be a document. What is that document? By which any right is created. Any right is created. Right is extended. Right is extinguished. Or somebody acknowledges his liability for certain property, for certain money. So that is valuable security. Sometimes I put the question, what is valuable security? Somebody creates, there is immediately, if you do not understand the definition correctly, then you may be confused. Sometimes it will not be possible to answer the valuable security. Valuable security is not a security of a thing. No. The valuable security is also a document, only a document, or purport to a document, should to be a document. Whereby any right, what it says, section 30 says, the words valuable security denote a document. So valuable security is a document which is or purport to be a document, either which is a document or purport said to be a document, whereby any right means a legal right, whereby any legal right is created. Legal right is created. Somebody transfers a property, somebody makes a will, somebody signs a promissory note, or when that is whereby legal right is created, extended. Previously some right, that is further more right is given, extended, transferred, restricted. Somebody undertakes not to do something, that is restricted, extinguished, or released, or whereby any person acknowledges that he lies under legal liability. It's a document or purport to a document whereby somebody acknowledges his liability, is liable, acknowledges, whereby any person acknowledges that he lies under legal liability or has not a certain legal right, or has not certain right. So this is a valuable document. This happens in many cases. What happens? A person is possibly taken, and he is asked to sign a document that he is liable to pay certain money to somebody. Or you sign a promissory note, or you make a bond that you will pay so much amount to somebody. So this is a valuable security. So what is it? This valuable security, sometimes you do not understand the definition of valuable security, you cannot understand what is that is this robbery. In robbery we find the valuable security. What it says? What is valuable security? The word valuable security denotes a document. In a document which is or purports to be a document, either which is a document or purports to be a document, whereby any legal right is created, extended, transferred, restricted, extinguished, or released, or whereby any person acknowledges that he lies under legal liability, or has not a certain legal. Somebody acknowledges that he has no right on a particular piece of land, he has no right on a particular car. So that is, if he signs a document, it's a document that will be treated as a valuable security. Illustration: A writes his name on the back of a bill of exchange. And the effect of this endorsement is to transfer the right to bill to any person who may become the lawful holder of it. This is also enforced is a valuable security. That is also valuable security, because in the document that is coming, this somebody writes his name on the reverse of the bill of exchange. So by writing that name, writing his name, that is treated as a valuable security. That is a valuable.
A will. What's a will? The words a will denote any testamentary document, not any type of testamentary document that will come to somebody will get its property after his death. That is a will. Now, 32. Words referred to act include illegal omission. When there is a word act, whoever does an act also illegal omission. What it says? Words referring to acts include illegal omissions. In every part of this code, except where a contrary intention appears. Every part of this code where any contrary intention appears from the context. Words which refer to acts done extend also to illegal. When there is act done, that will also be included as illegal omission. Act omission. The word act denotes as well as a series of acts as a single act. When series of acts, 5 blows will be treated as one act. So the word act denotes as well a series of acts as a single act. The word omission denotes always as a series of omission as a single. Series of omissions will be treated as single omission. Series of acts will be treated as what? Single act. Now section 34. Sometimes you should understand, this is a very important provision. What is section 34? Section 34 is a rule of evidence. It sometimes makes a person, that is joint liability. Sometimes we say also vicarious liability. What it says? Acts done by several persons in furtherance of common intention. If you understand this, then will be clear. Acts done by several persons in furtherance of common intention. What is furtherance? In advancement of their common intention. So in section 34, there must be a prior meeting of mind. The person must have done that act for the purpose of their common intention, in common intention. So then only section 34 is applicable. Section 34 itself is not an offense. It is the rule of evidence. What it says, when a criminal act is done, there must be a criminal act. A criminal act is done by several persons. Second ingredient, first criminal act, there must be several persons, more than one persons, in furtherance of the common intent. Criminal act is done by several persons in furtherance of common intention. In furtherance, in advancement of common intention of all. again in furtherance of common intention of all. If you read it word by word, then it is very easy to understand. What is that? Criminal act is done by several persons in furtherance of common intention of all. Then each of such person is liable for that act, in the same manner as if it were done by him alone. Then each of such person, each of those common person, that is several person, is liable for that act as if it were done by him alone. If you understand these words, it will be very clear. What is that? Criminal act is done by several persons in furtherance of common intention of all, then each of such person is liable for that act as if it were done by him alone. That is section 34. So it is not a punishment section, but it is only a rule of evidence. Makes somebody vicariously liable for the act of, if he has not done, but criminal act is done by several. He is simply, but his presence is required there, either in a distant place or in a nearby place. Suppose 3 to 4 persons, they entered into a particular house. They came for committing theft. 3 persons, they came to commit a theft or to assault somebody or to cause hurt somebody. Though, but they have the prior intention. They have the prior intention that they will commit that act. But 2 others are standing, one of them beat the another person. In such case, each of person, criminal act is done in furtherance of common intention by several persons, then each of such person is liable as if that act were done by him alone. So if you understand section 34 in this manner, how this word by word, criminal act is done by several persons in furtherance of common intention, then each of such person is liable for that act as if it were done by him alone. So here, what is, how this furtherance of common intention can be proved? Furtherance of common intention can, there may not be direct evidence, but it should be presumed, it should be, that should be known from the manner in which the act was committed, or that is the presence of the circumstances in which that was committed. So from that, such an inference can be drawn. There may not, it is very difficult to find out a direct evidence to prove the common intention. But such common intention, so that can be that can be presumed from how established. Common intention is a state of mind. Common intention is a state of mind of an accused, which can be inferred objectively from his conduct displayed in the course of the commission. From his conduct, how what he did during the course of the commission of a crime, at also prior and subsequent attendant prior circumstances, subsequent circumstances. Those are to be. Mere partition in the crime with other is not sufficient to attribute common intention to one of others involved in the crime. The subjective element in common intention therefore should be proved by objective. What is? Whether common intention is there. That means mere presence may not be, but in the manner how the act was committed, then how he took part in the crime, commission of the crime. From that, this common intention can be proved. Because it is very difficult, because common intention is always somebody's state of mind. How that state of mind can be proved? There may not be direct evidence. So for 3 to 4 persons, they came and simultaneously beat somebody. So another person was saying, and he was not objecting, nothing. From that, or thereafter, all of them 4 ran away. So from that, there may this common intention can be informed. So what is the ingredient? But what section recognizes the principle of vicarious liability in criminal jurisprudence? This section 34 that recognizes the vicarious liability in criminal jurisprudence. So we find a vicarious liability in tort. So it is a rule of evidence and does not create a substantive offense. It is not a substantive, a rule of evidence. So ingredient of section to attract section 34 IPC, two postulates are that is criminal act that is consisting of a series of acts should have been done not only by one person but by more than one person. There must be a doing of that act, that such act, individual act, cumulatively resulting in the commission of a criminal offence should have been in furtherance of the common intention. Furtherance means in advance for the purpose. So it is not necessary that each one of the accused must assault the deceased. It is not necessary. But it is enough if it is shown that they shared a common intention. It is enough that if it is proved that they are common intention. So what is statute is sharing upon common intention is must be there at the place of occurrence. At the place of occurrence, all persons must be present. Suppose there is somebody they wanted they had priorly they made a conspiracy, they made a plan to commit, but one person is not there. So he cannot be made liable as per the provisions of section 34, but he may be 120B, that may be there. So what is that is common intention? It is enough if it is shown that they shared a common intention to commit the offence, and in furtherance of that, each one played some role must be there. So, in a kind of joint liability, sometimes we also say joint liability in the doing of a criminal act. Only a rule of evidence. Rule of evidence, what is that? It is that is not a substantive offence. Section 34 is not a substantive. The distinctive feature of the section is the element of participation in action, the liability of one person for an offence committed by another in the course of criminal act perpetrated by several persons. You know. So here, that is, criminal act is done by several persons in furtherance of their common intention of all, then each of such person who participated in the crime will be vicariously liable, will be treated as if he is liable for that act, as if here criminal act, as if it were done by him alone. That is section 34. Section 34 sometimes it creates, that is a section 149. 149 what? There is also a provision for vicarious liability. When that is what? That is, there must be an unlawful assembly. In prosecution of common object of an unlawful assembly, one of the person commits something, then the other members of that unlawful assembly are also equal liable for that offence. So in prosecution of a common object of an unlawful assembly is something different in furtherance of common intention of all. So further common intention of all, as provided in section 34. So section 149 of the IPC also makes a joint liability. That is common, that is also vicarious liability. What it say provides section 149? When a member, when there is a common, that is unlawful assembly, in prosecution of the common object of that unlawful assembly, if one of the persons commits certain act, though others have no such intention to commit that act, they are equally liable for that act. That is section 149. For this 149 will be applicable when minimum member is 5 or more. For unlawful assembly, there must be an unlawful assembly, and in prosecution of the common object of that unlawful assembly. So here the furtherance of common intention, they are in prosecution of common object of that unlawful assembly. If one of the members commits something, then the others are also equal liable. So here, that is section 149. If we go through the provisions of section 149, because you are aware that is section 149, you compare the provisions of section 149 with section 34 of the IPC. What section 149 says? Every member of unlawful assembly guilty of offence committed in prosecution of common object. So every member of unlawful assembly guilty of offense. Every member of unlawful assembly committed in prosecution of common object. What it says? If an offense is committed, by any member of an unlawful assembly in prosecution of the common object of that assembly, in prosecution of the common object of that assembly, if an offense is committed, then then or such as the members of that assembly knew to be likely to commit, either committed or such of the members of that assembly knew to be likely to committed in prosecution of that object, every person who at the time of the committing of that offense is a member of the same assembly is guilty of that offense. Here liability is there, individual guilty of that offense. Once it is proved there is a common that is unlawful assembly, one of them is found guilty, then other will be treated as guilty. So what it says? The offense under this section, that is what it says? Section 105 has its foundation on constructive liability. Constructive, it is to be presumed that constructive liability. There is a vicarious liability, which is that is a sine qua non for its operation. On the common object and not in common intention. Common intention is not there, common. Mere presence in a non-lawful assembly cannot render a person liable unless there was a common object and he was actuated by the common object, and that object is one of those set out in section 141. What is unlawful assembly? That is, they are defined in section 141. So a common object on unlawful assembly is not proved, the accused person cannot be convicted. So common object is there. Section 30 it is that is Supreme Court held that alternative conviction of the accused persons with the aid of section 100 as well as section 34 is not illegal. Sometimes alternatively that can be. So what he says? So common object. There you prepare go through the definitions of both these sections. What is? If an offense is committed by any member of an unlawful, there is an unlawful assembly in prosecution of common object of that unlawful assembly. If an offense is committed, not a member, offense is committed, any member of an unlawful assembly is prosecution of the common assembly, or by any member, or by such as the members of that assembly knew to be likely to be committed in prosecution of the object, every person who at the time of committing of that offense is a member of that assembly is guilty of that offense. So section 34 and section 149 will first you go through the definitions of both these sections, then you will try to understand what is the difference. That there is a common object, there must be unlawful assembly, but in section 34 minimum member may not be 5, but in section 145 minimum member must be 5. There must be prior meeting of mind here, but in section 149 no prior meeting of common object and intention are there. Purpose, there must be a prior meeting, there is a purpose. At a spur of the moment many persons they gathered and they attacked a particular public servant. If one of them dealt a blow so that public servant died, then the other persons are also equally held guilty. That is by attracting the provisions of section 149 IPC. But here section 34 minimum, that is this common object is not there. Common intent in but furtherance of common intention. They are in prosecution of common object. Sometimes it is also overlapping. You understand, you very object, that is, if you do not understand the definitions correctly, you will be confused. What is section 34 and section 149? So at least you should remember, you must not be very that critical on the matter of the Kamji. You must not be confused, but you should, if you understand, in section 34 there is a furtherance of common intention. But in section 149, there must be an unlawful assembly, and in prosecution of common object of that assembly, if any member commits any offense, then or he knew that that such an offense is likely to be committed, then in such case that person will be held guilty. Who is the member of that unlawful assembly? Section 34. So, how Section 34 we have covered. In the next class, we'll discuss the remaining provisions from Section 35. Thank you all.